All right, good afternoon and welcome to Common Scenarios Triggering False Claims Act Violations. Today we are discussing part two of our three-part series. Today is construction and workforce issues. I am Matt Feinberg. I'm going to be a pseudo moderator for this webinar. If you've listened to one of our False Claims Act webinars before, you've probably heard me talking my face off. I'm joined today by Sarah Nash, who is the practice group chair for our labor and employment practice group, and Jessica duHoffmann, who's the practice group chair for our construction group. We're going to begin today with a little bit of a disclaimer. We are not providing legal advice to you today, and we are not creating an attorney-client relationship. We're doing the best we can to provide the information we have in a general sense. If you have specific questions about the circumstances you're facing, you're going to want to reach out to us separately, and our contact information will be on the last page of these slides, or you can find us on the PilieroMazza website. But what we say today won't necessarily apply to your specific circumstances, so please take everything we say as general information only and not as legal advice. A little bit of an overview of what we're going to talk about today. We're going to start with a very high-level explanation of what the False Claims Act is. This is not going to be a deep dive into the background and specifics of the False Claims Act. We're really going to hit the specific violations that come up frequently, excuse me, for construction contractors and FCA violations that arise out of employment practices. And we're going to focus the majority of our time on those topics. Sprinkled throughout, we're going to talk about some recent and landmark cases that highlight construction and workforce issues under the FCA. And so if you have questions about the FCA generally, you can refer back to one of our prior webinars, or of course you can reach out to me, Sarah, or Jessica at any time. So first, what is the False Claims Act? I'm sure you've heard it before. It's the primary vehicle for the government to combat fraud and collect money obtained through misrepresentation, or to retrieve money improperly withheld from the government. So this directly affects government contractors in particular, because they're constantly doing business with the federal government. For purposes of the False Claims Act, a claim is a request for money or property, and it could go either way, from the government to the contractor, or from the contractor to the government. The most common example you'll see is an invoice, but it could be a grant application or any number of other ways that companies request money from the government, either for services performed or under some other form of entitlement. When we talk about a claim being false, we mean that that claim to entitlement of money was somehow improper, incorrect, or unlawful. Or it could be a perfectly acceptable request for money, but it was supported by a misrepresentation, such as it's an invoice for a government contract where some contract requirement that is required of the person requesting the money, they're not complying, and yet, although they've performed the work to justify the payment, they are somehow out of compliance with the contract, and therefore it is considered a false statement at that point. But not all incorrect claims are violations of the False Claims Act, because there is an intent requirement that it goes into it. The False Claims Act requires, for liability purposes, actual knowledge, which is literal knowledge that you are breaking the rules or the law, recklessness, or deliberate indifference. And recklessness and deliberate indifference are sometimes two versions of the same concept. It's essentially disregarding a significant risk that your conduct violates the False Claims Act, and then performing that conduct anyway, and requesting the payment from the government regardless of whether you are in compliance or not. So there are some relevant types of False Claims Act violations which you should keep into consideration when listening to our panelists today and thinking about the cases we're going to talk about. First is a false claim or a false presentment claim. That means that someone is making an actual request for payment to the government. That's your invoice type of claim. A false record or false statement claim usually arises out of a proper invoice that is supported by a false representation. For instance, you might be talking about an invoice that is submitted on an 8A or STVOSB set-aside contract, where the company submitting the invoice is not actually eligible for that set-aside program. And you can create a false record or false statement through an express certification or implied certification. Express certifications are going to be the kinds of things you need to tell the government because your contract requires you to. Common example would be if you're submitting an invoice, you might have to certify that all subcontractors either have been paid or will be paid out of the government's payment. Or it could be an implied certification, which is something that you're just expected to do as part of your contract. For instance, comply with the terms and conditions of various statutes and laws affecting performers in your state or with the federal government. You may not actually have to certify that in your invoice, but it's expected and implied by the fact that you're performing on the contract. You have a reverse false claim, which is essentially where a company retains money that is owed to the government and doesn't pay it forward, and a conspiracy claim, which means that 2 or more people working in concert violated the False Claims Act in one of the above 3 bullet points. So we're going to talk a little bit about common FCA issues in construction, and I'm going to ask my colleague Jessica to talk a little bit about the broad categories of construction FCA issues we're going to talk about today.
Thank you, Matt. So the broader topics that we'll go into, and I see and often guide my clients on, are improper billing, and we'll get into the details of that. The small business set-aside type fraud, when you're involved in a government contract that's specific to small business or set-aside amounts that you're compliant with that. Work share non-compliance, then non-compliant or substandard products or services provided, and that, not every breach of contract case becomes an FCA issue, but we'll get into when non-compliance, particularly of specifications, could come up, or failure to supply conforming products could create an FCA violation. Overall contract non-compliance, again, not every breach of contract is an FCA violation, but some failures to meet the contract requirements could rise to the level of an FCA violation. Inflated REAs, claims for equitable adjustment, change orders, those are often what we guide our clients, my clients on, with respect to submitting REAs for delay claims, any kind of request for an equitable adjustment. How that is tabulated and the basis for that claim will often be scrutinized. And then we're going to talk about surety liability, which is a surety liable for its principal's FCA violations? And we'll get into that because that is kind of a recent, I wouldn't call it a trend. We hope it's not a trend, but it's certainly something that we're all going to be watching in terms of whether a surety can be held liable. And if we go to the next slide, I think we're going to be talking about improper billing first.
Well, we're going to start just really quickly and get an overview from Sarah about the employment practices we'll be talking about today as well.
That's right, not to be overlooked. Employment practices are important, especially in this context. So we'll talk a little bit about everyone's favorite topic, timesheet fraud. There is a myth that on government contracts, you can't bill for time, or there's a myth that you don't need to pay employees if the government isn't going to pay, and that is not accurate. And so that gets really messy when you're dealing with situations where maybe you can't bill the government for something and you have to navigate those payroll pressures. And so we'll talk a little bit about that. There is a really great mashup between labor and employment meets the Davis-Bacon Act in the construction world, specifically because of certified payrolls. There's an obligation, if any of you are government contractors in the construction field, hopefully you already know this, there is an obligation to submit certified payroll for your DBA contracts. And for those who might know, DOL recently updated landmark changes to the Davis-Bacon Act that are making it even more difficult to comply. And so it's important to stay ahead of that, not only for the DBA considerations, but also FCA considerations. We'll also talk a little bit about the sister act of the Davis-Bacon Act, which is the Service Contract Act, SCA, not to be confused with FCA. The SCA controls prevailing wages for service employees. And surprisingly, there are also some issues that you can step in from an FCA context. So we'll talk about those. And then lastly, everybody's favorite topic, retaliation. Talk a little bit about the pitfalls of retaliation in the context of the FCA.
Before we jump to the next slide, I was going to make a Whoopi Goldberg joke about the Sister Act, but I'm actually going to let that one fly. Let's kick it off, Jessica, with some discussion about improper billing.
Okay, improper billing. You know, this seems to be something that it seems to be a relatively easy task. Bill for the work that you performed, and you know, there are requirements in all the government contracts as to what you can bill for. You know, whether it's a fixed price, whether there's limitations in what you can and cannot bill for. But some of the most important things is make sure you're invoicing for work that was actually done and materials actually used. And one of the things that you will see often, and I question my clients, is to make sure that whether you're doing it on a percentage of completion, it could be an estimate, but make sure it's accurate. I have seen cases, and it has come up where companies have advance billed for work that's not actually done because of financial pressures. And if you get caught doing that, that is very well an FCA violation. Similarly, for materials not used, that will come up again if you're advance billing one. And I'm not talking about billing for materials that are stored. You could have a contract provision that'll entitle you to payment for stored materials under certain parameters. I'm talking about materials that aren't even there yet, haven't been ordered yet, haven't been installed yet, or worse, they're materials that are being billed for another project. And there are a few cases that I've seen where a particular contract may not allow invoicing for a particular material or scope of work, so they invoice it and bill it under another contract. And if you get caught doing that, that's an FCA violation. Invoicing for deficient work. That is a very complex topic because, again, when you invoice for work that's deficient, it has to be somewhat material. It cannot, as I said, not every breach of contract or failure to perform or conform your construction to the requirements of the contract is going to rise to an FCA level, and we'll get into that, but it can. If your work is deficient in its material to the contract and to the government's payment of that work, of that invoice for that work, deficient work, it can arise to an FCA violation. Deviations from project specifications, that goes into that same bucket. And project specifications go to everything from concrete mix and testing to particular types of equipment that need to be ordered, and a failure to meet the project specifications or to obtain from the government a change order to allow such a deviation could arise to an FCA violation. I've seen at least it alleged against one client that this was years and years and years ago on a government project where the HVAC system that was ordered and installed was not compliant with the particular specs. The government wanted actually a less efficient system. And my client thought, well, this is more efficient. It makes common sense. I'm going to offer it for the same price. It's actually more expensive, but I'm going to offer it to him. He thought he actually was doing a good thing. And you have to be careful with that, because even though it might be well intended, if you fail to meet the project specifications, you could be deemed to be in violation of the False Claims Act. False certifications of conditions of payment. That again could go to an express certification. Sometimes your contract documents will have specific certifications of conditions of payment. And then, of course, you have some that are set forth in the FAR, such as express on a fixed price contract, expressly certifying that you will pay your subcontractors. If you falsely certify a condition of payment, that can be a violation of the FCA. And then falsifying payment applications. Again, that can go to conditions of payment, but also including in your payment application exaggerated labor hours, exaggeration on the materials or supply costs. If it's a contract that maybe isn't a fixed price, but is a time and material, if you exaggerate the amounts and then submit that payment application, that very well could be a violation of the False Claims Act. And again, we're not talking about rudimentary mistakes in math. We're talking about, something that's either done intentionally or it was so reckless that the government's going to deem it that you had that intent. And so again, whoever's charged with submitting billing needs to be careful and pay attention to detail before submitting those requests to the government.
Jessica, the deviation from project specifications reminded me of a case I had a few years ago where the contract, the solicitation, I guess, required materials to be local, a certain percentage of materials to be locally sourced from the area around where the construction site was. In this case, it happened to be the Pacific Northwest. And the client had submitted in their bid that they were going to obtain a certain amount of wood to do cabinetry for a specific type of wood from the Pacific Northwest. And then when it came time for performance, about a year later, or maybe even later than that, that wood was no longer available. It was not sourceable from the Pacific Northwest, and they needed to get replacement wood of the same type of tree, but they were, getting it from somewhere else in the country. And although that did not turn into an FCA case, the government did bring up the fact that it was a false certification to have obtained this wood from elsewhere because it hadn't been disclosed and they didn't get a change order for it. And so what you were saying earlier made a really good point. Eventually, we were able to work that out with the government. But if that wasn't disclosed and the government found out later, you could very easily end up with a False Claims Act a violation at that point. So
right. And I can tell you that even when you feel like you have disclosed it to the government, we recently had a matter in which a material was supposed to be sourced. It was by American Act. And there really was no ability to get this particular product without really just a huge additional expense. And this was actually put in documents, but apparently it never really made it up to the contracting officer. So when it came to light that this particular material was coming from Mexico, it became a big deal, and we did have to go in there like a fire drill just to ensure that this didn't become an issue or a potential FCA violation.
So Jessica, you've talked about this a little bit, the false certifications of payment, but is there anything else you wanted to talk about that specific type of?
We talked about the express condition. I think that is what it is. I mean, you read your contracts, read your payment applications. If there's an express condition that needs to be met, make sure you're meeting it. The implied false certification is a little more complicated. Okay, you have to make it's something that's implicit. You imply that you've supplied the goods or the services, and you fail to disclose that there's a non-compliance with either a particular material statute, regulation, or contract requirement that makes the submission of the invoice misleading or half-truth is, I believe, how the courts are using it. Yes, I've supplied the materials you ordered, but it's a wink, wink. It's a half-truth because they don't really meet your specs. Well, again, because the government doesn't want every breach of contract claim to become a False Claims Act, I think that would have a chilling effect on government contracting in general. The courts have looked at it as, well, when is the non-disclosure material to the government's payment of the invoice. So they've looked at a common sense approach, which is, well, it's common sense. The government wouldn't pay your invoice if they knew that you failed to meet that spec. You will oftentimes have the government know that an issue exists regarding a particular construction, whether it's the wall doesn't, look straight, it doesn't appear to conform to the specifications, yet they will pay payment applications for percentages of completion that will include the installation of that wall. And so a lot of times the government will look, well, have you paid already knowing this? Or have you paid in similar cases knowing that there was a potential issue? So they will look at that. But it is somewhat of a common sense approach. It's not just the potential for harm. If you do something wrong, it could potentially harm. That's not necessarily the deciding factor. It gets complicated. It's very fact intensive. The safest way to avoid this false certification theory is to ensure that to the best of your ability, your goods and services comply with the specifications, the regulations that are incorporated into your contract.
So we have a great question from the audience. And the question, for those who can't see it pop up on their screen, is for materials not used, if you've got a firm fixed price contract and you don't end up using all of the material initially estimated, do you need to lower an invoice, or is there a sort of monetary threshold that makes it a material financial overpayment? And I think I'll kick it off with Jessica in a second, but I think we're going to be lawyers here and say it depends.
Yeah.
Because how much are we talking about? If you're talking about you ordered a certain number of panels of drywall because you expected at the beginning of the project to need to replace, I'm just going to pull a number out in there, 10% of all panels, because that's just how many panels tend to have defects in them, or you get too many nail pops, and you end up having a lower percentage of drywall that ends up with nail pops by the end of the project. That's probably not a material difference. But if you ended up with 7,000 panels of drywall in a major building that you had billed extra for the government, that's the kind of interaction with the government that you're going to want to disclose it. You're probably going to give them some sort of discount on the invoice. The question of whether it's material is ultimately going to depend on the totality of the circumstances. And like Jessica said, this common sense theory. So are you over on all of your materials because you misbid the job? Then you should probably give a credit back to the government. Are you able to use those products because they're perfectly fine in some private or other public contract? Maybe you give an invoice to the government or give a discount to the government. But if we're talking about a small amount of material overage and your order in the beginning and your estimate was reasonable when made, it's probably not going to be material, because the difference in price would probably not cause the government to refuse to pay an invoice for you. But Jessica, anything you want to add to that?
I mean, that's really also going to go to your contract, the language. So a lot of things can be, fixed price. There can also be line items for which you're entitled to an adjustment if you are over a certain percentage or under a certain percentage. But this, and I haven't looked at it in a while, but where that comes up is also a sole source. So if you are the sole bidder on something and you wildly overbid it, that could be a False Claims Act problem. So I would report it. But again, that is going to be very fact specific. And one of the first things I will always say on call, I need to see your contract. Because I need to see under what lens we're going to look at this before we decide, one, is there going to be a recommendation that you report it, and two, are you in some gray area with respect to the contract requirements of having overbilled for materials not used. So again, it starts with that analysis, and I don't mean to be vague, but again, it's very factually specific.
So I've got a couple of examples up on the board, which I will let Jessica talk about, but I want to, you'll see a big discrepancy here. We've got a $57.75 million settlement. We've got a $300,000 settlement. Those are obviously very different numbers. And that when you're reading these examples that we give today, just because the numbers might be lower or higher doesn't necessarily mean that the False Claims Act violation itself is less serious or more serious. It really is a fact-intensive inquiry. It could be that on the $300,000 settlement, there was a profit margin that was low, or the contract itself was a lower value, and so the potential for damages was lower. Just don't assume that we are putting up, the only examples we could find. We're picking out these examples because they seem to demonstrate what we're talking about pretty well. If you have specific worries about a contract you're on and how to handle it, you're going to want to address those questions directly to us, but don't take too much from just the examples we're giving here, because these are the cases that have either been made public or that we've seen in our own life. But go ahead and jump on these examples, Jessica. And,
sure. So the other thing I wanted to kind of jump in on what Matt said is one of the issues that can come up in a settlement amount is the ability to pay. So the government may have a really strong case against a basically defunct company and decides to just take what they can afford. So again, the settlement amount is not indicative of the seriousness of the violation necessarily. So the first one, that $60 million settlement to resolve allegations for, again, this is a group of contractors and subcontractors that overcharge the government for idle time for a bunch of tradesmen. And this came down to inquiry into the failing to adequately schedule the construction of a waste treatment facility. And, when I look at scheduling analyses, and I've submitted plenty of REAs for delay claims, and a big part of delay claims or a change order for delay will be that idle time. And how you measure that idle time is really important, that it's done correctly. It's based on accurate records. It's based on an accurate schedule that is not one of the things, if anyone here has ever worked with CPM scheduling, at least I know that they can be easily manipulated, which is why when I'm involved in a scheduling claim against, for example, if I have a subcontractor against a GC, I'm always going to ask for the natives because I want to see what manipulation happens in a schedule. I want to see whether the logic ties are correct, whether they've been removed, whether they've been played with. And honestly, I don't do that alone. I'm not a scheduling expert. I work with experts on this. But these are the reason why you want to work with experts on before you bill for idle time is you want to make sure the baseline schedule is proper. And then how you've got your baseline schedule and how you're going to compare that to what I call the as-built and how you're going to assess the idle time, because the government come in and say, well, your original schedule was flawed, and they'll have their own team of experts, and I have worked with government delay experts, and they're very good too. And so again, caution here is scheduling analyses. Make sure if you're doing it in-house, you have a team of qualified individuals. Whenever I'm involved in a claim, I will often ask for those schedules, and I can tell immediately by their response when I ask for the natives. If they're clutching their pearls, claiming they can't give them to us because it's some kind of confidentiality, or I've heard everything. That usually is my red flag. There's been manipulation of the schedule. If it's my red flag, it would be the government's red flag. So again, that case goes to a fraudulent billing for idle time that just wasn't proper. The next case is a settlement that involved billing for materials that just didn't exist. I can't tell you, and you can Google this. The government has nice websites where you can see the FCA settlements of the day, if you will. And I see this more than it comes up in a lot of cases where materials just don't exist on the project. They get billed. One of the recent cases I read, it was because the materials couldn't be billed on a particular project because I guess they reached their maximum. So they billed it on another task order. So you have to be careful that what you're billing for is something that was actually delivered.
Yeah, that's a really good point, Jessica. So money is always fungible in our brains, right? Just because you took the $20 out of your wallet, if you put it on the nightstand, you've still got $20. In the government contracting context, you don't get to move product or money or services between contracts without getting a change order from the government, because the government has only authorized you to do certain things. And so you can't borrow money from another contract to cover an overage on a task order over here. You just can't do it. So that's a good example, Jessica. One of the biggest trends in False Claims Act litigation over the last few years has been small business and set-aside fraud. And the Department of Justice and the Small Business Administration have really trained their eyes on contractors, and there are a lot of set-aside contracts in the construction space. Some of the most recent focuses have been where allegations that a prime contractor is ineligible as a small business or under a set-aside program to receive the contract that's being awarded. Sometimes that's from an initial standpoint, they were never eligible. Sometimes it's because that prime contractor has grown out of the program or has had a material change, like a change in ownership or a change in control, or maybe has gone through an acquisition and things have changed and the disclosures haven't been made. We also see a lot of investigations of fake and figurehead companies. And I mean no disrespect by saying this, but in FCA parlance, they sometimes refer to it as a rent-a-vet or rent-a-woman company that they want to be eligible for woman-owned small business contracts or service-disabled veteran-owned small business contracts. And so they get a friend who qualifies. That person doesn't actually do anything, and it is run by the owners of a large business or a teaming partner just to gain access to contracts that their larger businesses are not eligible for. I talked about this a little bit. You failure to meet the ownership or control or employee-based requirements. An employee-based requirement might be that in the hub zone program, you have to have a certain number of employees who live or work in a hub zone. And then there's affiliation issues, which happens a lot when there's common ownership of multiple companies. If an individual owns more than 50% of one company and owns 50% of another company, and they're doing a lot of business together, the reality might be that those businesses are considered affiliates of each other. And when we talk about small business programs, the size standard is determined by the revenues of all of your affiliates combined. And so sometimes you might have 4 small businesses all doing $20 million a year, but when you add them in as affiliates, you've got $80 million a year, and they're no longer small for the contract we're talking about. So some examples of that from the construction industry. We've got a $2.8 million settlement to resolve allegations that a construction contractor was claiming credit for and represented to the government that it was using an SDVOSB subcontractor, that's service disabled, veteran-owned small business subcontractor, to perform work despite knowing that that SDVOSB company was actually just a front and pass through for a large business. Similarly, we've got a $1.1 million settlement to resolve allegations that a large construction company separately set up a front company. So to qualify for SDVOSB set-asides. In that first example, the SDVOSB subcontractor was a legitimate business, but it essentially was passing through 100% of the subcontracted work to a large business and was just taking a profit on the work, which is not possible under most contracts. In the second, we're talking about a large business that actually used one of its employees, set up this fake construction company, and then obtained SDVOSB set-asides that the large business performed. And then we have an $188,000 settlement to resolve allegations that DBE certified, that's disadvantaged business enterprise, certified construction contractor, continue to recertify their eligibility for that program and obtain set-aside contracts and subcontracts, despite the owner's personal net worth increasing beyond the thresholds to qualify for the program. So you'll see this in the 8A program. Sometimes you'll see this in other set-aside programs. There's a threshold where the business and the owner are no longer considered disadvantaged or presumably disadvantaged. And that can be organic growth of the company. They've won a bunch of contracts using this certification. But the point of these programs is to bring success to small businesses, but then move them out so that new small businesses can gain access to these programs. And so when contractors misrepresent their eligibility, they are essentially taking the place of another contractor who would have received the contract had it not been for an improper company claiming eligibility. And one more example, a $2.5 million settlement by an engineering company and its owners. This resolved both criminal and civil investigations into allegations that the firm created new STVOSB companies by putting their relatives as the figureheads of these companies, but again, controlled by a large business. So we see a lot of that where a small business is actually operated by a large business, and that would violate the regulations. In a similar vein, we've got work share noncompliance, and this comes up a lot. This is sort of a hot button issue for the Department of Justice. They find a lot of problems with joint ventures. But for small business and set-aside contracts, there are limitations on subcontracting requirements, where the prime contractor is required to perform a certain amount of the work. If we're talking about construction, that's usually 15%, and it doesn't count materials. Whereas in a different type of contract, it's usually 50% of the amount paid by the government for performance, depending on the type of contract. So the prime contractor may be winning a large set-aside award that is by itself incapable of performing because it just doesn't have the manpower, the financial capital, or the access to subcontractors to perform the contract itself. So it's got to logically team with other parties, but you can't overwork the larger businesses on a set-aside contract. So we've got the performance of work requirements up there on the board for you. In a joint venture or mentor-protégé joint venture, the numbers are similar, but they change a little bit. The joint venture itself must perform at least 50% of the amount paid by the US government for performance, or 15% for construction contracts. The small business or the set-aside entity that is the basis for the joint venture's status must perform 40% of the joint venture's work. So in some contexts, a joint venture or mentor-protégé joint venture might help really up-and-coming but sort of fledgling new businesses, because they would only have to do 40% of that 15%. If that's how much the joint venture is performing. That makes it a much more manageable size project for a very small business, whereas it may be difficult for them to do 15% of the labor on a large construction contract.
And can I pop in here, because I think this is important. It's one thing that we've done apart from kind of the small business joint ventures, and which is really what this goes to. You can have joint ventures that are two large companies that are joining together to hopefully get the job. This does not discuss the antitrust issues and bid rigging that can go on. So keep that in mind. If you've got two equally sized companies that are joining together to bid something, make sure that you're talking to counsel about antitrust issues and potential bid rigging issues, for which that's a totally separate topic, and that this does not touch on those types of joint ventures.
Yeah, we could talk about that for hours.
Yeah.
On the other side of things, if I could jump in as well, it's also a good opportunity to remind folks that independent contractors are considered subcontractors. And so to the extent that you do have independent 1099s on your projects, those are going to be counted towards the subcontracting. numbers.
Yeah, that's a great point too. And we're going to talk a little bit about this in a later slide, because a lot of construction contractors hire workers that want to be considered independent contractors because they don't want taxes taken out of their pay. And you may have an agreement that allows for it, but the reality is that that's not what is usually permitted in a construction context, unless they are independently licensed and bonded. If they're working under your license and bond, they're an employee. And so they need to be categorized correctly so that, one, you're getting credit for your performance of work, but two, you're not running yourself into wage and hour violations that could result in completely separate litigation. But setting aside the limitations on subcontracting requirements for small businesses, a lot of federal contracts, particularly construction contracts, require the prime to have a subcontracting plan. A specific percentage of the work must be performed by small businesses or disadvantaged businesses. Some construction contracts, actually, I've seen, only allow a certain percentage of the work to be subcontracted regardless of the size, because of the businesses involved, because the government wants the prime itself to be performing. That would be particularly specialized work, and they want to have vetted the prime contractor themselves. So this goes a little bit to understanding the requirements of your contract, but you want to make sure that you're meeting any subcontracting plan requirement as well.
And that's an important issue, Matt, is understanding it before you bid it. What the requirements are. I know that I've had at least one case that they didn't realize what the subcontracting plan was, and at the time of bid, and it ended up being a huge delta between what was bid and what was required. So make sure you understand what the requirements are, before you price and bid it.
Yeah, we have another good question from the audience about whether similarly situated small businesses or companies eligible under a set-aside program count toward the prime's work. The answer is yes. In most situations, you will have to check your contract to ensure that the similarly situated rule does apply, because in some instances, I've seen contracts that specifically disclaim the similarly situated rule. I can't get too far into the weeds, because again, I gotta have an entire webinar about the similarly situated rule. But essentially what it means is that if you're working on a service disabled veteran-owned small business set-aside contract and you're a prime that is an STVOSB, you can subcontract work directly to another STVOSB, and that STVOSB's work would count as part of your work share. So that doesn't count as subcontract work, it's prime work. With regard to joint ventures, you truly have to be similarly situated to the set-aside status that is given to the contract. So one thing that gets people very confused is they may be a small business may be the prime, and they may be subcontracting to a small business, and they just assume that there is a similarly situated rule that applies. But if that contract was set aside for 8A companies and the companies are not similarly situated in that instance, then they do not count as prime contract work share. There are a lot of webinars and blogs out there from PilieroMazza about similarly situated rule and limitations on subcontracting. We'll probably have another one within the next couple of months, and please reach out to us if you have questions about that after the webinar. But I can't give you all of the facts in the short time we have, unfortunately. A couple of quick examples. I'm going to skip to the second one. There's a $1 million settlement to resolve claims that a large business contractor performed all of the disadvantaged business enterprise, that's DBE again, assigned work in violation of performance of work requirements in the contract. Essentially, in this instance, the contract required a certain percentage of work be performed by DBEs. It was a construction in the transportation industry. And instead of actually having the DBE do the work, they issued a subcontract to the DBE, but the large business actually did the work. Defeats the purpose of the subcontracting requirement. And then $2 million fine in a criminal proceeding. So this didn't actually go civil, where a large business was a subcontractor to a construction project, a massive construction project about 10 years ago. And it continued to just take on more and more work in the project, ran over the small business prime contractor and didn't, took control and didn't let them perform, and drove the small business work share below 15%. The government ultimately criminally indicted and got a conviction through a guilty plea on other issues, but the False Claims Act was a heavy player in that specific instance. So Jessica, let me throw it back to you and talk a little bit about non-compliant and substandard products on construction contracts.
So again, as I mentioned earlier, not every breach is a FCA violation, but when looking at products or services that don't meet the requirements of the contract, and that's particularly the specs usually, the standard is, do they meet the minimum industry standard? Are they actually worthless services that so below the standard expected? It's kind of like the clutching your pearls, like you're almost in shock, that it's almost as if they failed to provide anything at all. I saw an interesting page. It's worthless services, not worth less, meaning just because it's not worth as much that you're going to get hit. No, if it's just a diminished value, that theory is not necessarily accepted. It's not what's going to make the case fly on an FCA violation. Really, to me, it's kind of goes back to that common sense. Going to some examples, and I'm going to speed up because I recognize we're short on time. The first one is $10 million for these castings that failed lab tests and did not meet the standards of the Navy. And there was also a falsification of test results that hid those failures, which I think is what lended to this bigger settlement. But that was a substandard steel component for installation on subs. You had another one. This one was a little interesting to me. It's a nearly $5 million settlement to resolve allegations that a construction contractor on a state road that was federally funded, that the hot mix asphalt didn't have sufficient binder to meet the specs. And so you'll often see concrete, I represent a lot of concrete suppliers, concrete contractors, you start getting into specifications and what that means from stress standards and testings. You have to be careful. It can become an FCA violation. Altering components of a bridge by cutting and burning multiple sections of reinforced steel. That ended up in a $637,000 settlement. So again, these are issues where they failed to meet specs and corners were cut. The two other examples, $35 million settlement. This was a big one. This dealt with improper invoicing, where a very large contractor was alleged to have submitted and lied about repairs on military housing to get incentive payments under the contract. And then the last was a $1.75 million settlement that construction contractor used unauthorized substandard materials. Again, failed to meet the specs and failed to obtain approval to use an alternative material. And in this case, the material was found to be less than what was anticipated in this or required in the specs.
So yeah, you talked a lot about contract non-compliance. We finally got to those slides. What say you, Jessica?
So again, regulations, you've got to look at your contract. You've got to see what regulations are included in your contract and make sure you comply with them. Contracts, specifications can also impose style, brand, or quality requirements. And in some cases, they won't call a company out by name as being the required source, but they will basically set the specs so only one supplier can meet that requirement. And you'll see that. So make sure that you're complying with the contract specs. The contract language forms the basis for whether you're going to have an express or implied certification of performance. So it's all going to go back to your contract. If you're being audited or reviewed or questioned about contract compliance, the first thing we're going to ask for if you were to call us is that contract. And then we're going to need to know what exactly was it that you failed to comply with. And is it a product or material? Is it what kind of implied certification are we talking about? Is this a common sense situation where what you've supplied is basically so far off the mark that it basically becomes worthless, and you submitted a payment application implicitly certifying that you met the requirements of the contract spec. And then some other examples is our $4.6 million settlement to resolve allegations that a contractor knowingly failed to perform quality assurance testing that's required under its construction contract. I don't know a single construction contract that doesn't have quality assurance requirements. $457,000 settlement to resolve allegations that a construction contractor knowingly misrepresented compliance with, again, contractual requirements to build a road in accordance with detailed contract specifications. $161,000 settlement to resolve claims that a construction contractor imported roofing materials from China without country of origin markings, contrary to the contract customs and laws. You also, this is where Buy America could come up. Make sure you're sourcing your materials and you're compliant with the contract requirements. That you can have countries that are exempted. You can have countries, and again, this is going to go to, you've got to read your contract. Where do you have to source materials? And can you get an exception? And when would you get that? So again, you've got to look at your contract, but if you're in violation of sourcing requirements, that can be an FCA violation.
Yeah, we talked a lot about Buy American Act and Trade Agreements Act yesterday in our webinar on government contracting. We're not going to touch on it today beyond this, but if you have questions about BAA, TAA compliance, you can go back and check that webinar when it hits YouTube, and you'll get some good stuff from Jackie Unger, who's our resident BAA, TAA expert here at PilieroMazza.
And I brought her in recently on a construction claim involving BAA issues, so she's great. The last one is $11 million settlement to resolve basically a construction contractor supplied electrical connectors that had not been tested. And again, these were found to be, or alleged to be, False Claims Act violations, and they were resolved. And you could see the amounts can be quite significant, especially if you're a smaller company.
All right, so Jessica touched on this a little earlier. When you're submitting requests for equitable adjustment, you can run into a lot of FCA claims. So Jessica, if you could give us an idea about that.
I mean, we could do an REA claim issue. I know that, when you submit an REA, you certify it. And so there's usually two components. If you're doing a delay claim, you've got to do the delay time analysis, and then you've got to do the cost analysis. And you both have to be compliant. You can run into a lot of problems. You've got to read your contract in terms of what is actually collectible, what is something that can be included, and a lot of times your contract will speak to that. But then you also have to be aware of the FAR and what is allowed to be billed and what is not allowed to be billed. So, you have to be careful, and this can be, again, the subject. You've got to be worried about double billing. Are you including in your claim things that have already been resolved by prior change orders, whether that's extensions of time or extensions of additional funds? You have to make sure you back that out of your REA claim. Otherwise, it's double billing. Double billing, you can trace that a lot in REA claims. Are you asking for funds that are not allowed under the FAR clauses? Are your overhead amounts including entertainment costs, lobbying costs? So again, working with the proper experts in your REA claims to ensure that you're compliant with both the contract and the federal regulations is going to be important. And then there's nuanced issues in cases like if you're asking for equipment costs. A lot of companies will automatically go to their certain manuals, like Army Corps of Engineers has a manual for operator-owned equipment and what you can charge. But you can't use those manuals where you keep actual accounting records of those costs. And then if you're, if you're using the manual, are you using like equipment? So I've seen cases where they say, okay, well, we supplied this equipment, here's the rate from the manual, but their equipment was actually 20 years older. And so it's an inflated claim. again, that can be massive grounds for a ton of claims by the government that it's an FCA violation. So again, work carefully on your REA claims, particularly delay claims. They're complicated. If you're doing them in-house, be very careful. I tend to use experts, particularly delay experts, for those because I'm always worried about it. I know in one case that we had with the VA, we submitted a claim and a pass-through, and the government audited our claim, and when they didn't find anything, they hired a third party to re-audit it. And a client, and it was multiple millions of dollars, but they paid us only after that second audit. So you do not want to have to go through that. So make sure, and I tend to, if I help a client on an REA claim, when in doubt, leave it out, is kind of my motto, because if you have to suffer one of those audits, you don't want to lose that kind of sleep.
So we've put up some examples on the board. We're not going to go through these because they're all basically just reiterating what Jessica just said. But the takeaway here is that the U.S. government often heavily scrutinizes REAs, particularly larger REAs where there's a significant change in work due to any number of claims, such as differing site conditions. And often the government will come back and say that this claim is over, or this claim or REA is overstated, either because your damages are overestimated or misrepresented, or because the labor hours you're claiming were not actually worked or materials were not actually used. And so that has ongoing ramifications, because not only will there be an investigation under the FCA, the government will ask to stay the REA and claim process to go through that investigation. So you're without those, even if it turns out that you're correct for every cent, you might be 4 or 5 years down the road waiting for that REA to be paid out. We're going to go really quickly through surety liability. So the theory under surety liability is that a surety bonds out both performance and payment bonds for the contract, and the surety's liability is to essentially pay the government or cure a breach by the contractor. Any of these FCA violations is considered a breach of contract, particularly if they weren't eligible or if they're not meeting contract requirements. And so the theory that has been advanced pretty frequently in the last couple years is, should the surety be liable for sort of conspiring with these contractors to breach their contracts? The landmark case is 2017, it's Skolik versus Narula. Full disclaimer, I was involved in that case. I was representing one of the defendants. It's still ongoing, but I'm no longer representing them. In 2017, the federal court found that sureties can be liable under the FCA for bonding out a fraudulent set-aside contract. That is a very narrow ruling. It was on a motion to dismiss, so it's not really binding, but it is persuasive authority in future cases. Then 2 years ago in the same case, the surety actually obtained summary judgment. The judge found that there is no evidence that the surety defendants knew the set-aside program requirements or intended to deceive the government. And frankly, the sureties weren't even required to know the government regulations. That doesn't mean that sureties are off the hook. That means that in the circumstances specific to that case, the sureties didn't have the knowledge necessary in order to meet the intent standard under the FCA. But that doesn't mean that in a future case, a plaintiff wouldn't be able to make out a case against a surety. Those facts might support it. What we're saying here is, on summary judgment, it's a very fact-specific case, and what the plaintiff has been able to prove at that stage. The motion to dismiss says it is possible for sureties to be liable, and so that's where surety companies and, candidly, the contractor have to be worried, because contractors usually sign personal guarantees and indemnification agreements in order to secure their bond. And so if the surety is somehow responsible or is sued under the FCA, even if for some reason the contractor isn't, the surety may be able to come back after the contractor for things like attorney's fees and costs incurred in an FCA litigation, investigation costs, or potential liability under the FCA, and they could be coming after the person that personally guaranteed that bond. So we're going to keep an eye on it. Like Jessica said earlier, we hope it isn't an actual trend, but does seem to be where some whistleblowers are going, and it seems to be the place where they want to stay because they think it's lucrative. So Sarah's been sitting very quietly and patiently for us to get to her section. We finally got to the employment side. Sarah, you want to talk a little bit about timesheet fraud? And we are going to go over everybody, but hopefully we will make it quick.
I'll keep it brief, and I have appreciated listening to all these ins and outs. It's a very complicated area, so I'm glad that you guys have had Matt and Jessica to sort of go over these common pitfalls that we're seeing. Timesheet fraud is really the most common area that we find issues in sort of the context of labor and employment. Part of the problem here is contractors, and we talked about this a little bit in one of the examples that Jessica went over, contractors might be submitting time that wasn't actually worked or that was excessive based on the contract proposal. And it can be exacerbated by the fact that what you bill to the government is not necessarily consistent with what you are obligated to pay employees for. So I'll give you an example, for example. Employees who work more than non-exempt employees, that's hourly employees, generally your construction folks are going to be non-exempt. Those employees are entitled to time and a half for all hours worked over 40 in a work week. However, just because your employees are entitled to time and a half for all hours worked over 40 in a work week doesn't necessarily mean that your contract allows for it. In fact, to the contrary, we'll often hear contractors and clients say, you know, the contract doesn't allow for overtime. But that doesn't mean you don't have to pay for it. And so there are some areas where just because you're obligated to pay employees for that time worked doesn't necessarily mean that you are entitled to bill the government for the time. And it's not just those sort of nuanced areas of labor and employment law. It also applies, especially in the post-COVID world where a lot of folks are remote, and you maybe can't observe their work. Obviously not in the construction world, people are on site performing a lot of these tasks. But we've seen examples where, you know, you might have an employee who's been submitting their timesheets religiously, you know, 8 hours a day, every day, come to find they haven't once showed up to do the work. They just haven't been available. Or you might find recently saw an example of this, that they're engaged by 2 different contractors and they've been billing for work that they've been performing, you know, just twice. And so these are issues where it's very important as an employer that you are tracking your employees' work, that you are keeping on top of whether they're actually performing that work, because you don't want to be in a situation where you had reason to believe that they were not performing the work. Maybe you knew that they hadn't checked in for a while. You're just submitting their timesheets, or maybe there's a subcontractor employee that's been missing. You've been seeing them submit their timesheets. Those are all issues that are going to fall squarely within timesheet fraud, and it's very dangerous to get there, especially if you end up in a situation where the government is going to ask for that money back. And just because the government's asking for that money back doesn't mean you can go back to the employee and say, hey, I'd like you to write me a check for the amount that you overbilled for. It doesn't usually work that way. So you're in a situation where you're often paying back that money just out of your bottom line.
So Sarah,
yeah, go ahead, Jessica.
Towards that end, and because I do think it comes up on a more granular, when you're submitting for a change order for a particular scope of work where you have to track the time, contractors have gotten in trouble for doing exactly this, just assigning 8 hours without really specifying what the person was doing. So if you get an instruction for changed work and you have to track the labor, make sure you're doing particularly with respect to time and timesheets, where it's particular enough that it can be traceable to that particular change order as opposed to the contract overall. Because when you go to submit that change order request, again, it's going to be based on those time records. So make sure that they can be substantiated.
Excellent point. And on the flip side, I mean, let's say that the employee was working all that time. You just can't prove it. So it's good. Any of those tools that you can use to show, yes, we have evidence that reflects, whether it's you know, the badge swipes or emails that they were looking at. We have evidence to support that they were actually doing that work. That's all going to be helpful in pushing back on a claim like this. We have some examples here. I think we kind of went over big picture general considerations. I don't think we need to spend more time on this slide, unless you or either of you two have something.
Well, the Davis-Bacon, I mean, I've seen the Davis-Bacon violations. I think misclassification tends to be the bigger issue I've seen lately.
Yeah, so that's the next big thing. So under the Davis-Bacon Act, and the reason that the Davis-Bacon Act falls into the crosshairs of the SCA frequently is because there are these lovely requirements to submit weekly certified payrolls. And if folks on the line are familiar with the certified payroll form, there is a specific shout out on that form to the FCA that essentially says, you know, misrepresentations on this form could be a violation of the False Claims Act. That said, in my experience, you know, this often happens in labor and employment contexts. Folks figure, no, you know, it's not rocket science. How hard can it be to fill out this form? I'll just figure it out. But this is one of those areas where it's not necessarily intuitive. And Jessica, you mentioned misclassification is a huge problem in the Davis-Bacon world. Not least of which because often it's based on prevailing practices in the locality. So especially if you are operating, even if it's a different, like DC versus Maryland, different prevailing practices can control. And if you're familiar, there are wage determinations that go hand in hand with Davis-Bacon contracts. And those wage determinations essentially are not just incorporating the prevailing wages and the prevailing fringe, they're also incorporating prevailing practices. So if you're trying to classify folks, well, you know, in the industry, it's fine, they're all helpers. That's generally not going to fly in this context. So, and it's especially important that you get it right because of the False Claims Act implications of, you know, signing off and certifying that you are properly classifying employees, that you have paid them correctly, and that they actually perform the work that you're representing that they performed. And these are a few examples of how it can be very expensive to get these kinds of classifications wrong. The DBA was recently updated by DOL. The final rule also implicate additional penalties. So it's not just FCA, it's not just DBA, this whole world of compliance and penalties can apply, including debarment, suspension, and all of the ugly pieces of the SCA that attach. Very briefly, talk about the SCA, Service Contract Act. This is the law that we talked about earlier that deals with service contractors. There are similar obligations to pay service employees prevailing wages. You do not have a certified payroll obligation when it comes to the Service Contract Act, though, which is why you don't generally see it as frequently in the FCA world. That said, you know, it has come up. And so we were talking before we got on this webinar that there are certain instances where, you know, contractors have been sued for misrepresenting that they are compliant with the SCA, submitting invoices essentially representing that they are compliant. And I will mention the SCA has a lot of curveballs that are not, again, intuitive, that mean that it's an easy area where contractors can often get it wrong. I'll also use this as an opportunity to plug a deadline that's coming up. The OFCCP, Office of Federal Contract Compliance Programs, a couple of years ago made a change requiring contractors to upload their affirmative action plans and certify that those plans are in fact in place. That certification this year is coming up on July 1. So just a good reminder, another opportunity for certification, FCA issues come up and that deadline is coming. So keep it on your radars.
When we talk about the False Claims Act and employment issues, probably the most important and risky thing involved is a retaliation claim, because the False Claims Act itself Of course, it's very scary. It allows for treble damages and attorney's fees and a whole lot of other remedies, including penalties for the actual violation itself. But it also includes an anti-retaliation provision, which states that any employee, contractor, or agent cannot be retaliated against for taking, quote, lawful acts, end quote, in furtherance of the FCA. So that's a very broad application. You could have an employee who says, I saw Johnny Rocket leave the work site an hour early on Wednesday, and I just saw his time card happen to be sitting there, and he billed 8 hours that day, or put in 8 hours on the daily report. Just wanted to let you know. Then they report it again a week later, and a week later they do it again. And the contractor says, this guy is a problem employee. All he ever does is complain. He's tattletaling on his employees. We're going to fire him. And they fire him. Well, Johnny Rocket, or I'm sorry, whoever the complainant is, has shown that there's potentially an FCA violation because Johnny Rocket is overbilling his time. And so if the catalyst for the termination was making this report, this protected disclosure, then that termination could result in a retaliation claim, which allows the person to be reinstated, allows them to get 2 times their back wages and benefits that they lost, other potential damages. And of course, they could be a key TAM relator, which allows them to get a percentage of the overall government's recovery. And so retaliation is a really important topic. I'm going to throw this over to Sarah in a second. We're going to talk much more about this in the 3rd installment of our webinar series that comes up next week. But Sarah, why don't you give us some more thoughts on retaliation, and then we will very quickly wrap up.
Great. Yeah, just to say that the Davis-Bacon Act and the Service Contract Act don't specifically have private rights of action. And so FCA anti-retaliation provisions can be a common tool that key TAM plaintiffs use to rely on for, protected whistleblower activity. So as Matt mentioned, it can be much broader than just the employment context. It applies to contractors or agents. But when it comes to employees, that can be a very common, message that's issued, and it can be very broad in terms of what constitutes retaliation. Generally, it's going to be any adverse action that's taken against an individual, whether that's, often we think of termination, but did you fail to promote them? Were they unfairly transferred? Did you take away certain benefits? There is a lot of opportunities to argue that an employee has been treated poorly because of relating important, protected information. What I generally recommend to clients in order to sort of limit the risk of finding a retaliation is just make clear that you have a good open door policy. Make sure that your code of ethics is up to date and accurate. Make sure that you have policies and procedures in place that make clear that retaliation is not permitted and that whistleblowers are protected under company policies. All of these can go a long way in, ensuring that you don't have to climb out of a hole when it comes to a retaliation claim.
Yeah, so we've gone over, and I'm going to talk about one last tiny thing about retaliation while I put our contact information up on the screen. So one thing to remember about FCA retaliation, it doesn't just apply to employees. It applies to independent contractors. So if you've got an independent contractor working on a project, or if you've got a subcontractor, sometimes even a subcontractor employee, an agent such as a vendor or consultant, all of those people are given anti-retaliation benefits under the False Claims Act. Now, it depends on the circumstances of each case, but you shouldn't think that just because a person is not an employee, that they can't come back and sue you later under the FCA if they feel like you have taken some sort of adverse action against them as a result of their protected activity. The last thing I will say is, what's the biggest risk in the FCA? Even for companies that are fully compliant, it's the filing of the FCA suit, because there's an investigation, usually multiple years. The vast majority, overwhelming majority of contractors are trying to do it right. And so when we go back to one of the early slides I mentioned, we have that knowledge requirement. It's either knowledge, recklessness, or deliberate indifference. It can be easy to reach that recklessness standard in some circumstances, a lot harder to reach that actual knowledge standard. But if you're not paying attention to your P's and Q's, if you're not crossing your T's and dotting your I's, you could reach that recklessness standard. And then you're defending a lawsuit and an investigation that goes for multiple years in federal court. And that can be just as dangerous. You know, we talk about these settlements, but that doesn't factor in the attorney's fees that had to be paid to get those resolved or to defend against the action. So just some food for thought. These are very important issues, and I'm sure we've left you with some questions. If you'd like to reach out to us directly, I know we didn't get to all the questions that came up in the chat box. So you can reach out to us directly at any of the emails on your screen, or you can give us a call and we'd be happy to talk through your issue with you. Please join us for our third installment, which will be next week. And we hope you've enjoyed our discussion, and look forward to seeing you on a future webinar. Sarah, Jessica, thanks for joining me, and I look forward to the next one.
Thanks, everyone.
Thanks, Matt.